Welcome back to the fifth episode of the Cut Off podcast. To frame today's conversation, I want you to picture this. A parent walks into court believing the judge will see the truth, only to watch the alienator's lies treated as facts. They leave more confused and more erased than when they arrived. The parent sits down, hand shaking, heart pounding, expecting evidence and their child's sudden reaction to matter. But instead, the judge glances at a file, hears a rehearsed accusation, and the narrative flips. Suddenly, they're not a loving parent anymore. They're the high conflict, unstable, uncooperative one. And just like that, the court's misunderstanding becomes another layer of trauma. This episode is about why that happens. Marisa, let's start with that courtroom scene we just described. Why is it so common for courts to misunderstand parental alienation and often fall for the alienator's narrative?
Well, courts, they frequently misunderstand parental alienation really because the legal system is designed to evaluate discrete incidents. They're not designed to evaluate long-term relational manipulation. Alienation, it rarely presents as one obvious event, unlike other forms of abuse. What it is it's a campaign. It's a slow, cumulative shaping of a child's perceptions through subtle influence, repetition, and gatekeeping, really. And that can be exceptionally difficult to detect in brief hearings, especially when the case is framed as high conflict or two parents who just simply can't get along. Alienated parents, they are often walking into court. They're already traumatized. They're grieving the loss of access to their child and then simultaneously being forced to defend their character, their motives, and their sanity. That combination, it can trigger intense emotions, outrage, for one, fear, disbelief, and despair. There's a hypervigilance and urgency for that parent who's being alienated to really impress upon the system how wrong the other side is and how deceiving and deceitful they are. And with all those emotions that they're experiencing, they often can present like they're unstable, they're emotional, they're erratic. And what happens is those trauma-driven reactions, they can read as instability, obsession, or just simply poor co-parenting. And even when there's a predictable response, what I'll say is even those emotions, if you would think about it, when parents' children are being ripped away from them, all those emotions, they're a predictable response to prolonged psychological and rational harm, but the judge doesn't see it that way. Often they just see how that parent in that moment is presenting. Meanwhile, the alienating parent, the parent that's doing the alienating, they often appear calm, they're controlled, they're child-focused, and on the surface, because they're not in the acute stage of loss, they're the ones in control, they're the ones that have the children. So they're managing the story that they've so meticulously weaved and the deceit. They might use polished language, selective documentation, and plausible sounding concerns. They might say, the child's anxious, the other parent is unsafe, we're just following the child's wishes. And that fits neatly into legal categories. False allegations, half-truths, and carefully curated narratives, they can therefore feel more credible than the alienating parent's distressed, complex, emotionally charged reality. As a result, the parent who's being alienated, they can inadvertently discredit themselves. And it isn't because they lack truth, but because the trauma, it's going to affect their composure. It's going to affect their communication style and their strategy, really, because often they're not strategic. They're still in the defense mode. So the court may misinterpret the emotional intensity of the parent that's being alienated as proof of unfitness, rather than just recognizing it as the predictable psychological impact of losing a child through coercive dynamics and repeated character attacks.
And so many parents walk into court believing, the truth will win, only to find out themselves dismissed. What does that feel like? Because you've lived through this, right?
You're absolutely right. I can say I had on a personal note, I had a long history of false allegations and repeated aggressive attacks, but I was upset. And what I can say is it can feel re-traumatizing. Like reality suddenly stops. It stops mattering. Like all the facts don't matter. All the paper trail, all the evidence, the psychiatric tests and exams, the drug tests, you name it, depending on each person's circumstance. But all the truth and all the facts, they can be thrown easily out the window if a parent doesn't compose themselves well in front of the judge. You can walk in believing the system is built to protect children and reward honesty. Or that's what we would like to think. That's the ideal we have, right, about the court system. And then you realize the courtroom, it's not measuring truth the way you expected it. It's measuring credibility, presentation more so, and paperwork in a short window of time. So when your lived experience is reduced to a he said versus she said, or labeled as high conflict, it can feel like you're being erased while your child is slipping further away. I'll say, at the same time, the alienating parent often isn't operating with a shared code of ethics. They appear composed, convincing, and even child-focused, while delivering a narrative that's just designed to tarnish the other parent's reputation. In extreme cases, what the targeted parent is up against feels rehearsed. The statements are pre-planned. The claims are carefully curated. And sometimes even a child's language, it can sound coached or scripted. And watching a child repeat accusations sounding coached or scripted doesn't sound like them, can feel like witnessing a hostage situation in slow motion. Some parents, they have the unfortunate experience of having their children called to stand. And they're watching their children being tightly controlled by that other parent. And they know what's happening. They can identify that the child knows and feels like they don't have a choice but to say what they've been told to say. This collision, this raw grief and urgency against someone else's polished deception, it creates a specific kind of shock. It's not just disappointment. It's a betrayal that's really hard to quantify. It's disorientation. It's the sense of being punished for caring, while the person doing the damage, they look calm and therefore more believable. So afterward, many parents, they might describe this same internal crash. If the court didn't see it, will anyone believe me? And that moment alone, it can strip away trust in the entire legal system, in fairness, in justice, and sometimes even in your own ability to communicate, because you realize you aren't simply fighting for parenting time. You're fighting for your reality to be recognized and for truth to be, when it seems like all the factual evidence is in front of you and the truth is so blatant and obvious to the parent that's being alienated, it's very hard for them to rationalize how other people can't see it at times. So when a court gets the story wrong, it doesn't just misread the conflict. It can accidentally institutionalize the rupture is what happens. And a wrong finding, it can hurt the bond in multiple layers of ways. It can invalidate the child's rejection. If the court's language implies the targeted parent is unsafe, unstable, or the problem, the child absorbs that as official proof. It kind of justifies, well, even though I've been told to say this and I feel pressure to say this, I suppose I was supposed to say this all along. And that's how the child might start thinking. It turns doubt into certainty. And the child will think, well, if the judge agrees that what I'm saying and doing is right, then it must be the case. It rewards avoidance and it punishes connection. When contact is reduced, supervised, or made conditional in a way that treats the targeted parent as a suspect, the child gets fewer chances to experience warmth, repair, and normalcy. The relationship then weakens from lack of access, and it's like a muscle that's not allowed to move. The relationship just atrophies is what happens. So in closing, I'll say it deepens the loyalty binds and it deepens the fear of the child. Children often feel they must choose sides to stay emotionally safe. A court decision can intensify that pressure. If I'm close to either the mother or the father, the child might think I'm betraying the parent I live with or the one the court seemed to protect. That fear it's powerful and it's self-protective, and it changes how the targeted parent is allowed to show up. After being falsely cast as harmful, the targeted parent often becomes guarded, overly careful, or desperate to prove that they're good. And in that desperation, they just can present themselves more unstable, unfortunately. And that can make interactions feel tense, unnatural, and exactly the opposite of what rebuilds trust between the parent and their child.
Thank you, Marisa, for that thorough explanation. Now, if we move a little bit to the clinical side of things, why do so many therapists and evaluators miss the signs of parental alienation or mistake them for normal conflict?
The truth is, therapists and evaluators, they often miss parental alienation because they're trained to treat family distress as two sides contributing. So they're trained to look at both sides and see more or less what both sides are doing wrong. And they're it's impressed upon them to prioritize immediate emotional presentation over long-term behavior patterns. Again, it's similar to why the judge can make poor rulings and not recognize the alienation. Is at that moment, those therapists, they're analyzing, they're assessing those parents' reactions and what they're saying. They're not looking at the history and the evidence that's leading up to why. And even the parent that's being alienated, they could be trying to rattle off and present all of the history and all of the information to impress it upon the clinicians. And their response is, hold on, let's just address this here and now. Let's not get historical. Let's see what we can do to address what's going on now. And they don't want to hear what the parent has to say regarding all the information that's necessary really to really analyze and understand, have a firmer depth of understanding of what's going on. So if an evaluator, they only see a few sessions, they rely heavily on self-report, and the pattern can obviously be easy to miss. They also often mistake the alienation for a normal conflict because the child's rejection, it can appear authentic. Children can sound mature, even rehearsed. So without careful attention, that gets interpreted as independence. They might say, well, the child has a voice and we have to validate their voice and listen to what they have to say. And they don't take into account that this also could be a potential sign of influence. Another reason is that the alienating dynamics can mimic familiar clinical storylines, whether it's a protective parent, an anxious child, a controlling ex, a high conflict divorce. If the alienating parent presents as calm, they're organized, and they're child-focused, and the targeted parent presents as distressed, urgent, and reactive, clinicians may unconsciously side with the smoother narrative. So the targeted parent's intensity can be misread as pathology, as obviously that they have a lot of mental health issues, while the alienator's composure is mistaken for credibility. Also, finally, many clinicians, they're cautious because the topic is controversial and it's high risk. They may avoid naming alienation without what they consider definitive proof, especially when allegations of abuse are raised. So they default to safer labels, such as co-parenting conflict, enmeshment, or parent-child estrangement. Even when the clinical picture includes hallmark sides that are disproportionate rejection, lack of ambivalence, reflexive alignment with one parent, and rejection that escalates when contact increases. So, I mean, there's a lot of obvious signs of parental alienation. And again, the real problem here is clinicians, healthcare clinicians, because there's not a DSM diagnosis, there's not an ICD coding, if you will, and they don't really understand this dynamic form of abuse. They miss these obvious signs that are mainstream in almost all alienation cases. So, in short, alienation, it's missed when professionals treat it like a disagreement instead of what it is often. It's a power and influence dynamic, and it reshapes a child's perceptions and requires pattern-based assessment, not snapshot impressions.
Yeah, thank you, Marisa. So what I hear you saying is that actually not having a DSM code fuels confusion, mislabeling, and misdiagnosis, right?
Absolutely. What it is when you don't have that code, professionals often default to the closest available labels. So without that code and without the justification of it, without making that code widespread and understood, and what happens is courts, therapists, and evaluators are trained to think and recognize clinical frameworks. Parental alienation, it doesn't become validated and real until truly there is a DSM code. And I mean, our healthcare system it's ruled by insurance-driven systems. and often they require a billable diagnosis. So instead of naming the relational influence process, they may label the parent who's being targeted the reaction of the child's symptoms. They could mislabel the wrong problem. Alienation is a pattern of a coercive influence and relationship sabotage. But without a formal diagnostic category, it can be folded into vague terms such as high conflict, estrangement, or just adjustment issues, which it really minimizes the mechanism and treats it like a typical breakup dynamic. And when they do that, they often then can't help but look into faults of the parent that's being alienated. And they're quick to assign blame on that parent and say, well, what did they do to justify this disproportionate reaction of this child? There must be something behind this. So in turn, they misdiagnose the targeted parent. And the parent who's being cut off presents with these trauma symptoms. They're hypervigilant. They feel very urgent. There's an emotional intensity about them. They suffer from, unfortunately, a lot of clinical symptoms such as grief, sleep disruption, depression. And without a framework that recognizes the context of why this parent is acting this way and how they're presenting, clinicians, they may interpret these trauma-driven responses as instability, personality issues, they could impart personality disorders onto that parent. You know, we live in a system that's very quick to want to label and categorize parents with the way that, or adults really, with the way they're acting. What happens then is they're pathologizing the injured party rather than identifying the ongoing relational harm. So they're misreading the child's presentation. Children, when they're affected by alienation dynamics, they can appear rigid, certain, and adult-like in their accusations, and sometimes without ambivalence or tenderness towards the rejected parent. So what happens then is the clinicians, they look at that and say, this child must have gone through hell. I mean, they just are looking to escape this scenario. And they have sympathy for the child when really what they don't understand is that child is under enormous pressure to act and say the way that they're presenting. And if a child is told repeatedly to say certain things and to repeat certain things to professionals, what happens is that impressionable child, they start believing that some of that's true. And they start justifying, well, what I'm saying must be right. So in return, that child can appear even more adamant in what they're saying and how they're scripting things. So I think it's really the most important part of this entire piece is a DSM code. It influences legitimacy. In court, in clinical settings, the absence of a formal diagnosis can create the impression that parental alienation, it's not real and it's unproven, or merely it's a rhetorical claim. Despite the fact that the child's symptoms in the family can be clinically observable, the system ends up treating alienation as an opinion while treating other labels as objective truth. And if you think about it, we know as a society that there are many adults in history that have been, for lack of better terminology, brainwashed and manipulated by cults. So it's in some ways, it's almost ridiculous to think that can't happen to children by the parents that they love. It only makes rational sense that the same thing can happen to children. So the bottom line is without a DSM code, the pattern, it often goes unnamed. So the system names what it can. It'll use words such as conflict, anxiety, depression, a difficult parent. And once those labels enter the records, they can shape decisions, treatment plans, and custody outcomes in ways that are really hard to reverse.
Thanks, Marisa, for that. And as we here on the Cutoff podcast with you, Marisa Conway, are, shining light on this systemic damage that parental alienation does and how to stop it, I want to ask, what changes do courts and clinicians urgently need in order to stop alienation from, being ignored and mishandled?
There's not one magic reform. They need a shaped or a shared pattern-based way of thinking that separates normal divorce conflict from coercive influence and relationship sabotage, and then responds early, consistently, and proportionately. So what courts urgently need is they need early screening for pattern red flags, not just incidents. So when speaking to this, when there's repeated interference with contact, with gatekeeping of the child, where early on the parents are not letting the other parent see the child, chronic last minute cancellations, excessive calls and texts during the other parent's time, which I experienced early on whenever I saw my son's, my ex and his family had him on the phone constantly to control his time with me. Refusal to share school medical information and sudden child rejection without proportional cause. So a shift from credibility theater to corroboration. So less weight on who sounds calm in court, and there needs to be more weight on timelines and what happened. Third-party records, school medical therapist exchanges, and consistency over time. As an example, I had a long documented history of my sons responding to me as they should within texts and phone calls. And then the moment I left my ex, that communication dwindled and stopped. And I mean, that's factual evidence that clearly there was gatekeeping involved. And the communication I had a history of with the phone and the text, there was nothing at all abusive in my language between myself and my children. And that's factual evidence that there was a normal, healthy relationship that supports that. But like myself and other parents, often they come to court with all this information and evidence, but ultimately the judge hears what the children have to say, and they don't take into account that these children are put in this impossible position. There needs to be orders that protect the child's access to both parents. So there needs to be clear, enforceable parenting time provisions, neutral exchange plans, and consequences for repeated interference, and rapid return dates when problems arise. There needs to be specialized training for judges, guardians, and custody personnel. Training on loyalty binds, coercive control dynamics, coached rehearsed language, and why a distressed targeted parent, they can look unstable while still being the safer attachment. So in short, there really needs to avoid a false equivalence in high conflict cases, meaning some cases are not two parents who can't communicate. They are one parent undermining the child's relationship with the other. So they're treating sabotage as mutual conflict. It mismanages the risk. So it's very easy for them to, for the court system to have a custody evaluator say, well, both parents need to work. You know, there's always two people that create a problem. And it's very hard for them to still identify that the control and the gatekeeping and the difficulty of the other parent, the influence that they have. So what clinicians and evaluators, they really urgently most need is they need a structured process, multi-source collateral, and a timeline review, behavior pattern analysis, not just interviews. Alienation is rarely identifiable from self-reporting alone. That the ultimate decision of the family court judge and the system should not be on the reporting of the children and the parents. They really need to take into account all the evidence that's presented in front of them.
Thank you. And when this happens, when the system misreads these alienated parents' case, how can those parents protect themselves and their credibility if they're being dismissed?
Sure. I'll say this. I've said this multiple times, but I can't repeat this enough. Is the bottom line is the most urgent change that the parent needs to do is they need speed and consistency. The alienation dynamics worsen with time. So the longer the child practices rejection and the system reinforces it through reduced contact, vague orders, or indefinitive therapy first, the harder it is to undo. So effective intervention is it's early, it's structured, and protects ongoing relationship time with the facts that are assessed. This point can't be overexpressed. It really is necessary because as time progresses, the alienation just deepens. So if the system misreads their case, parents, they can protect themselves by shifting from "I'll finally be heard" to disciplined credibility management. They need to be calm, consistent, documented, and child-centered. The goal is to make the truth easy to verify and hard to distort. How many parents can protect themselves and their credibility? First, always try your hardest to regulate yourself and your responses. No matter what is said here or in the future, the court is always going to reward composure. So it's imperative for parents to practice a measured tone in hearings, emails, and exchanges. The trauma is real, and we shouldn't discount that. But visible reactivity by the parent that's being victimized, it's almost always going to be misinterpreted as instability. Also, too, it's important to present the facts, to tell a timeline, but not tell a tragedy. The court's going to respond, or they should respond, to the facts and the timeline of everything that happened. So you want to leave out adjectives that are incriminating, that are overly aggressive, even though they might be justifiable. Because judges and evaluators, they understand patterns. It's important to build a simple chronology with dates, missed exchanges, blocked calls, school and medical interference, sudden shifts in the child's language and behavior, and your attempts to resolve them. If you can, document like a professional. Keep records factual and brief. Screenshots, calendar logs, school portal messages, medical summaries, even police reports if they're relevant, and third-party confirmations. Avoid long emotional narratives. Stick to who, what, when, where. And that will help you. A good acronym when you're documenting these things is BIF. So it's brief, informative, friendly, and firm. And the healthcare system recognizes this as well. So you want to avoid things such as sarcasm, diagnoses, moral arguments. What you want to do is you want to write your messages as if a judge will read them and become eventually they may. You need to stop proving how damaging and how terrible or how immoral or how evil or how wrong or how abusive this other parent is. You need to focus on the impact of their behavior. It's important to use terms such as contact was denied and phrases, information wasn't shared, child was told X, therapy school access was blocked. Courts will move faster on observable conduct rather than motive. So if you can prove you can prove the parent's motive without being explicit with what it is, the court is much more likely to take what you have to say into account. It's also important, obviously, to always be visibly child-centered, to always act and convey your emotions and convey your wishes that you always have your child's best interests in mind. So it's important to show consistent efforts that prioritize the child, offering makeup time, proposing neutral exchanges, supporting routines, attending school events, staying respectful in front of your child, and encouraging the child's relationship with the other parent. It's important to create a support and a strategy team. So a trauma-informed therapist for you is something that may be a valuable resource to consider. A competent custody attorney, of course, is a necessity. And if possible, a coach or an advocate who helps you stay organized and regulated. Your job is to stay stable, the parent that's being alienated, and consistent over time. One thing that's really important to do, and equally stressful in a lot of situations, is you need to prepare for evaluations like it's an interview. You really shouldn't perform your pain. You should bring concise documents, answer what's asked, and own any imperfections, and return to major themes like safety, stability, relationship, cooperation, and consistency. You want to avoid credibility traps. So no social media rants, no retaliatory allegations without evidence, no over-texting, no behavior that's bad-mouthing in your part. So even justifiable anger can be weaponized against you. So a strong anchor phrase parents can use sometimes might be, I'm not here to punish the other parent. I'm here to protect my child's right to have a healthy relationship with both parents. Supported by a clear, consistent schedule and documented facts. So when you repeat phrases such as that are calm, they're collected, and it's showing that they're child-centered, you're much more likely to have the judge stop and listen to you and really take into account who you are and how potentially erroneous the other information might be that's being painted against you. So really, ultimately, in the end, I can't stress enough that the priority here is composure over everything else.
Well, that's a wealth of tips for for other parents who are in the same situation. And from previous episodes, you have also explained, the toolkit of the alienator, how to recognize their tactics and all the tips of documenting. So I recommend to all the listeners to go and see the previous episodes as well. But finally, Marisa, if you could tell professionals one thing to stop further harm, what would that be?
It's an excellent question. What I'll say is you shouldn't confuse a child's certainty with a child's safety. Don't confuse a targeted parent's distress as unfitness. It's really important to slow down and put yourself in that parent's shoes as they're hearing all these allegations made against them. Think about how they may feel and look for the patterns, not just the narratives. A calm, articulate story can still be manipulative. A distraught parent can still be the safer attachment. When you treat a rigid rejection as the child's truth without testing it against collateral facts, timelines, and developmental appropriateness, you can unintentionally cement the very dynamic that's harming that child. So the single most protective move is verify before you validate. Look at the history. Look at the information and the documentation that's being presented in front of you. Look at the history of the relationship that parent had with their child if they're presenting it to you, and what they said they did all these things with this child and all the time they spent with this child. Validate the child's feelings, yes, but verify the claims. Assess influence and loyalty binds and protect the child's right to love both parents without fear or pressure.
Well, today we made one thing very clear. Parents aren't failing the system is failing them, actually. If you've been dismissed, misread, or mislabeled, remember, you are not the problem, you are not to blame, and your truth matters. Join us next time as we keep turning pain into clarity and clarity into power. Thank you, Marisa.